Now we are diving into the very details of an ABS contract. The text. The words. Remember our example of the university student and his university wanting to negotiate an ABS contract? Let us now have a closer look at typical phrasing that appears to be just fine. The user is not authorized to utilize the sample for any commercial purposes. The user is not allowed to apply for a patent. These two clauses seem to be clearly formulated, especially as you are dealing with a university, not a company. However, they contain vicious traps that could be unfavorable to your party. Let's start with commercial purposes. What exactly does that mean? Is it the scar cream, the Band-Aid, or any other product? Of course, but there's more. Consider processes using our sample. For instance, tanning leather or cleaning metal. Even the mere transfer of digital data can be an act of commercial use. But a commercial purpose starts even before that. If the use of the sample has potential to lead to a product, process, method, data or information that can be protected through a patent, this is already a commercial purpose. Even if it is a university that obtains the patent, it can certainly carry commercial value. In fact, obtaining patents is a core business for universities. Speaking of the university, how can you be sure the university is not acting on behalf or funded for its research by an entity with commercial interests? Third-party funding for university research is very common nowadays. Companies and industries invest big money in university research, and they expect results. You should even ask yourself, who paid for the student's trip? Later on, after some successful research, the student might have the idea to quit the university and create a startup to commercialize his knowledge. Who knows? And how is this possible to prove? Because you can't read somebody's mind, it is virtually impossible to prove someone's intention. And in the end, commercial use is an intention. Building an obligation with the intention being a key criterion leads to an impossible legal situation. Try to capture all possible pathways and scenarios and make sure your ABS contract is as watertight as possible. Back to our clause. So you want to forbid commercial use. Fair enough. The question is, what if the contracting party does not comply with this? What will the consequences be? It is fundamental to clearly define the consequences for such a breach. But wait. Why do you want to forbid commercial use? It is far better, whenever possible, to regulate actions and obligations in a positive manner. For example, it is favourable to allow commercial activities and actions that may lead to the generation of benefits, instead of forbidding them outright. The key is to impose enforceable conditions that will guarantee a fair share of benefits flows back to you and clear consequences for when this does not happen. And also, please bear in mind, a contract cannot restrict someone from obtaining a patent. If the application fulfills the requirements and conditions, the patent will be granted, regardless of what your contract says. OK, now remember our judge? Since he isn't likely to be familiar with any of this, he needs to find all this information, every detail we have talked about, within the contract. Only then will he be able to properly assess the case. So what would be a better wording for our clause example? How can we bind the university best? In the event that the user takes any steps towards the commercial use or commercial activities concerning any parts of the subject matter under the contract, the user shall at any stage of the innovation process involve researchers from the provider country in a manner such as they qualify as or are recognized as the co-inventors to a patentable invention. This should work. Please remember, what we have just done in this exercise for one small paragraph must be applied to the entire contract. You must use the same approach and logic for all clauses in your ABS contract. Look at every detail from the judge's perspective. Your ABS contract has to cover all possible scenarios and pathways and translate them into binding contractual language. Here are your 3 takeaways. 1. Draft the contract in a manner that captures likely scenarios. Define what user actions need consent of the provider. 2. Carefully define verifiable trigger points for the user's obligation. Consider how these trigger points will be chosen and defined in the text. Stipulate clearly how the provider country shall obtain information and evidence as to whether the trigger points have been reached. 3. Specify clear consequences and remedies that can be invoked in the case of a violation of any obligation in the contract.